Hello everyone, this is Michael Haynes from HeaR from Haynes.com, bringing you another crash course training session, this one on workplace sexual harassment. In light of all the news reports lately of sexual harassment that has happened in Hollywood and politics, it's important that we talk about what's happening in our own workplaces. Sexual harassment is a problem that impacts more than movie stars. It's in our restaurants, it's in our hotels, our factories, and of course in our offices. But we can work to prevent it and stop it. This training video is a crash course version of a longer 30 to 90 minute session on how to identify and prevent sexual harassment in the workplace. By viewing this training, you'll be able to explain the basic legal definition of sexual harassment, apply it to situations in your workplace, and take action steps to prevent or stop future instances of sexual harassment against you or others in your organization. There will be several questions to think about throughout this session. Just stop the video, ponder it, and then resume it when you're ready to continue. So first, what comes to mind when you hear the term sexual harassment? Now, in the in-person training sessions that I do for this, we talk about the different things that people say and why those words are elicited. But on your screen, you'll see a few examples of the words that many of you are probably thinking or what has been said in sessions. What is illegal sexual harassment? So sexual harassment is a form of sex discrimination in the workplace. It's predatory conduct that harms the target due to its unwelcome and offensive nature. Anyone in the workplace can be a sexual harassment predator or a target. Rank and file line workers, managers, supervisors, executives, and even clients and consumers from outside the workplace can be the predator or a target. Sexual harassment disrupts the workplace. It's harmful for both the target and the employer and the organization as a whole, and it is, of course, illegal. Employers can be financially liable for sexual harassment taking place at work, and it can ruin the lives of individuals. It must be stopped immediately. Title VII of the Federal Civil Rights Act of 1964 forbids discrimination on the basis of sex, and Department of Labor regulations define sexual harassment as part of that type of discrimination. Illegal sexual harassment is any unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. The key part being unwelcome. Now, many states have anti-discrimination laws that go further than the federal law, so be sure to see what your state offers in additional protection. For example, here in Michigan, where I live, we have the Elliott-Larsen Civil Rights Act that extends the reach of Title VII to all employers instead of the Title VII standard 15 or more employees requirement. So in Michigan, all employers are covered by this discrimination that is sexual harassment. All right, time for a quick quiz. Quick question. True or false? Sexual harassment only occurs when an employee is a target of unwelcome physical contact. Well, that's of course false. Sexual harassment can take both physical and verbal forms. It can appear as verbal threats or lewd jokes and emails, but predatory behavior can also be physical through unwelcome acts of grabbing, touching, and even repetitive brushing, as long as it's unwelcome. No matter what form it takes, sexual harassment harms both the target and the organization as a whole. There are two types of sexual harassment: quid pro quo and hostile work environment. The first type, or quid pro quo, also known as this for that, is the easier type of harassment to identify. It involves a predator with some form of authority over the target, making some aspect of employment, like a promotion, pay or benefits, or even continued employment termination, contingent on an unwanted sexual favor. The exchange can appear as an offer or as a threat. For example, a predator could offer the target a promotion if she would sleep with him. That would be the offer form. The predator could also threaten to fire the target if she didn't perform a sexual act. The key identifier of quid pro quo sexual harassment is that there's an exchange offered that involves an unwanted sexual approach. Quid pro quo harassment can be clearly explicit or implied. The previous situations I just gave you, those are explicit examples. You can hear the offer for an exchange in what exactly was said. But many times quid pro quo happens without the clear offer or threat being made. It can be implied through the context of the conversation. For example, a predator could be touching the target inappropriately or using language that creates the implication of sexual advances related to an employment decision. It's important for you to be aware of whether you're the target of a quid pro quo sexual harassment situation. If you're having a conversation about your employment situation with an authority figure like a manager or a supervisor, and you sense that some aspect of your employment is being tied to an unwanted sexual advance, then you're likely in a quid pro quo harassment situation and should report it right away. It's quid pro quo, this for that. There's an exchange and an authority figure. Now let's talk about hostile work environment. Hostile work environment, that's the true kitchen sink category of sexual harassment. This type of harassment occurs when the sexual conduct or speech taking place in the workplace is so severe and so offensive that it creates an intimidating, hostile, or offensive work environment. That's in quotes from the regulations. Anybody in the workplace can create a hostile work environment. And it doesn't have to be one person. It could be a group of people causing the hostility. And it can be non-employees like customer and vendors. One example of customers creating this that's commonly held in cases is that if a hotel has problems with guests frequently calling housekeeping for them to come to their rooms for an issue, then the housekeepers get there and the guests are exposing themselves without clothes. If the hotel doesn't take action to prevent these situations from happening, then that hotel employer could be liable for the hostile work environment harassment that is created by these customers. Now, this is the stuff that just makes you want to cringe when you hear it or see it. Hostile work environment has that cringe factor where things like sexual explicit jokes and emails, unwanted touching, name calling, somebody who just does not take no for an answer on a date request or sexual favor, you name it. Lots of conduct and talk that just doesn't belong in the workplace, and it is illegal. If you're not sure if the activity in your workplace is creating a hostile work environment, go with your gut feeling. If the activity gives you that cringe factor, doesn't feel right, then it needs to stop immediately before someone is harmed and before someone files a lawsuit. A hostile work environment doesn't even have to be directed at a particular person to be harmful. Anybody affected by the offensive behavior is a victim in the eyes of the law. There are many cases where the perpetrators may have brutally disparaged an entire gender at work. They're just talking about a gender and disparaging just that gender. Well, the court can find that any employees of that gender who are in the area that can overhear those jokes and those disparaging comments, well, they could be considered victims of harassment. However, it does take more than a few tasteless jokes to create a full hostile work environment. The conduct has to be so severe that it interferes with the target's work performance. You know, like if the situation gets so bad that the target takes time off work to avoid the predator. Now, the EEOC is the federal agency that handles harassment complaints. They'll look at the context of the situation to determine if things are bad enough to rise to the point where it creates an intimidating and hostile workplace. They'll look at things like the frequency of the behavior, the severity of the unwanted behavior, the conduct of both the predator and the targets, the context of the whole alleged harassment situation, and of course the workplace culture. So the EEOC, and then if they allow you to sue the courts, will look, they care about the total context of the alleged harassment, and they look at how a reasonable person would feel in the target's shoes. There have been cases where the workplace culture was so inherently inappropriate that sexual harassment claims failed. For example, in the 90s, a writer on the super popular TV show Friends lost her hostile work environment lawsuit against Warner Brothers because the court said that the writer's room was a creative workplace that used sexual humor to create popular television. The workplace culture in that writer's room was a place that encouraged crude and sexual talk to enhance their productivity, not a hostile work environment. The work culture prevented a lawsuit about sexual harassment because that's just how the workplace was. Time to think a minute. What does your workplace culture look like? How would you describe it? Is there any part of it that you think a new employee or someone would perceive there to be creating a hostile workplace? If so, how can you address that? Take a moment, pause the video, think about this. Is there something in your workplace right now that could be perceived as a hostile working environment or offensive behavior? That if you can think of something, that has to be stopped immediately, or you could have a bigger problem. Now, let's have another true or false question. True or false, you cannot sexually harass a member of the same sex. Well, that's false. Sexual harassment law doesn't care about gender, only the nature of the conduct and the words used by the predator. There are over 7,000 cases of sexual harassment filed each year with the EEOC. 17% of those are filed by men. Same-sex harassment is illegal harassment as well. Men can harass other men, women can harass other women. Yes, the most common claim is a woman filing a claim against harassment by a man, but men can also be harassed by women, and of course same-sex harassment is also illegal. So now that we know what sexual harassment is, let's talk about how to prevent and stop it. First of all, here's what employers can do. First, review your current sexual harassment policies. Create them if you don't have them already. SHRM, the Society for Human Resources Management, has great sample policies that can help you get started. Make sure your processes for reporting harassment are very clear and easy to follow by your employees. Create a bystander intervention policy that encourages witnesses to help stop and report any offensive behavior that they see. Number 2, invest in training. Train everybody in your organization from top to bottom about the importance of diversity, inclusion, and how to stop sexual harassment. Make sure your employees know how your policies work and are trained to effectively respond if harassment is taking place in your workplace. It's one thing to have a policy, but you have to train the people on how to use it. 3, work on your workplace culture. Develop a more inclusive, positive work culture that does not tolerate harassment of any kind. If you develop your workplace culture to be better, positive, more inclusive, you're not going to have sexual harassment problems because it's not going to be accepted by the employees that you have. Through your hiring policies and the way, if your culture sustains a certain type of employee, it should be someone who's not going to be interested in being an offensive person, being a predator, and that will weed out sexual harassment potential just there. Finally, be responsive to complaints and act on reports. When you hear that someone is being harassed, take action on that complaint immediately. The worst thing that you can do is ignore your employees' complaints. It won't be long before the EEOC is calling you and you have an expensive lawsuit on your hands and your staff cohesion is obliterated. Act immediately on any report that you receive. Consider them all legitimate until otherwise investigated. Now let's talk about what you all can do as individual employees. Let's start with true or false question again. If you are being harassed, there's nothing you can do about it except leave your job. True or false? Well, this one's false. If you are being sexually harassed at work, just remember the acronym SELF. Take care of yourself. Follow SELF and you can help stop and prevent sexual harassment. So S, speak up. Tell the person offending you that what they're doing, their conduct, their words offend you, and tell them to stop. E, escalate. If they don't stop, tell a supervisor or an HR rep. If the predator is your manager or your supervisor, go to their manager or supervisor. Go up the ladder as much as you need to make sure it gets reported and hopefully stopped. The L is for list. Write everything down. List it all down. When it happens, while it's fresh in your mind, so that you have a good record of what you were thinking and feeling at the time. You may need to give police reports later, testify in a court hearing, or just need a little refresher or recollection of what happened. Sometimes these cases, if they go to the extreme, they take a long time to finish, and you might forget the details over time. So write it down immediately. And if your employer has not rectified the situation, F, file a complaint with the EEOC. If the EEOC cannot negotiate a resolution with your employer, then they will give you a letter that allows you to sue your employer in court for this harassment. Then the courts will deal with it and move on from there. But most importantly, of all of these things, keep yourself safe. Remove yourself from any situation that feels like it could escalate into a dangerous situation. Sometimes harassment is unfortunately the precursor to an assault, so get away and report incidents immediately. Even when you are not the target of predatory behavior, you have an obligation as a bystander, as a witness, to help stop sexual harassment when you see it. How do you know that harassment's happening? Well, just remember that cringe factor. If the behavior you're witnessing makes you uncomfortable, it's probably making the target uncomfortable too. So intervene if possible, and definitely report what you've seen. Now, if this was an in-person and a longer training session, we'd now take a look at some examples of harassment situations in the workplace and test our knowledge. But since this is an online crash course that you're kind of listening to on your own, I'll leave the homework for you to do on your own. So here's what you need to do to test this. Find a way to watch the awesome workplace TV show The Office. Episode 2 of Season 2. It's been on Netflix. Hopefully you can find it. But it's relevantly titled Sexual Harassment. That episode is filled with tons of offensive behavior in the workplace. Your mission is to identify any of the incidents of sexual harassment, think about how the targets and the bystanders can stop what's happening, and then think about what the company can do to prevent those acts from happening in the future. It's a good test of what you've learned today because of how pervasive the sexual harassment issues are in that episode. Thanks for joining me on this important training session. Here are some great resources to check out. Be sure to check out more videos and HR-focused articles and insight at hrfromhaynes.com. And if you're interested in having a 30 to 90 minute version of this done in your workplace or for your employees, contact me at mikehayneslaw@gmail.com. Thanks again.